Welcome to Reflections. I'm your host, Patrick Tomlinson, and thank you for staying with us for another segment with a very, very accomplished guest, Dr. Wilfred Holness. As we said the last time, Dr. Holness is a patent attorney practicing in the state of New York. He's also has his Ph.D. in molecular biology,
Molecular biomedicine.
molecular biomedicine, and the last time he started drilling down for us in the subject of patents and trademark. So Dr. Holness, I'd like us for this program to look at specific industries. I'd like to.
Right.
So welcome again.
Sir, thank you for having me.
And thank you for coming. So how, or if I'm a person that is involved in one of these three industries specifically, particularly the music industry, what are some of the things? I sing a song, I go to the studio. What are some of the things that I need to be aware of as a small business person, emerging business person?
Music is a different approach
Mm-hmm.
because what's still large, still looming in music is copyright law. And you find copyright law making its first appearance on the Constitution in Article 1, Section 8. You also find patents there also. And because these are called the useful arts, and these arts are deemed very important in order to develop a society. So these rights are given to the creators of these specific arts like music, dance, songwriting, especially literary writing books. Now, they have to be creative. These books have to be creative. These things,
When you say creative, what you mean? What is the definition of creative?
If you cannot, which has been ruled on, you cannot have like the telephone book. Telephone book is not going to be copyrightable.
Or the Bible?
Well, a Bible is not copyrightable because we don't know who really wrote the Bible. Unless you're saying God wrote the Bible, then I guess it wouldn't be copyrightable. But the ways you can lose copyright is if X amount of time lapses, if the person, the copyright holder, has been dead for a certain amount of time, you could lose copyright. But when you're dealing with music and that, you're looking at copywriting law, and it has to be original, and it's not a big, should I say, it's not a big hurdle to overcome. Looking at the hair products, you're looking at a composition of matter. It's going to be under patents. It has to be useful, it has to be novel, and it has to be non-obvious.
For me to get a copyright or
to get a patent.
Patent.
On the hair. Oh man, I just missed my trick.
Yeah, so you say the hair products have to be.
Yeah, these are composition of matter, and they have to pass that bar, that level,
Threshold.
the threshold, in order for them to be considered by the United States Patent and Trademark Office. The copyright is not governed by the United States Patent and Trademark Office. You'd find the filing of a copyright in the Library of Congress. What was the other one we were looking at? Baking?
Yes, baking. Let's say I came up with a novel way of baking buns or biscuits or bread or puddings.
That would fall under a patent. That would be under a process or a methodology.
Okay.
And you'd have a method of making such and such and so forth. And that would be your preamble to your patent.
Okay.
Your claims.
So if I'm baking bun and I decide to go out, buy equipment and started baking bun and distributing bun, can somebody come and tell me to cease and desist because they have a patent on baking buns? Or
they would have to do it, but they'd have a tremendous uphill bar to overcome. which is going to be obviousness. Because it's obvious to throw flour or dough in the oven and get a bun.
Okay.
So that's your argument with they call it non-obviousness.
Mm-hmm.
So it has to be non-obvious.
Okay.
It has to be never been done before. If it's been done before, now think about that bar to overcome. If this invention has never been done before, you're entitled to a patent. If it's been done before, you're not. If it's been obvious, even though it hasn't been done, but it's obvious to do something, then you'd lose your right to the patent.
Let's say I came up with a methodology of, removing wrinkles on the skin, or, making the skin look more rejuvenated. What applies in that case?
That would be a method of reducing wrinkles on the skin?
Yeah, something like that.
I'm telling you what it would be right. This is outright.
Mm-hmm.
Method, well, I'd probably change the wording to make it a little more broader, because that's one of the things you want. You want your patent, if it's issued, to not just cover this one little area. You want it to cover as much as possible.
Mm-hmm.
So somebody can say, well, it does cover that. So because the ultimate reason for these patents is it gives you a right to take somebody to court. And you're on the strong side once you've taken them to court, because you have this patent.
Okay.
So this is why you want to have a patent. This is why you want to have the trademark.
Mm-hmm.
This is why you want to have your work copyrighted.
Mm-hmm.
So that when you go to court, you're on the strong side.
You said you wanted to look at 3 specific cases or examples earlier.
Well, let's look at. I'll show you. You can combine. I was thinking about combining the different IPs. Like we talked about Kentucky Fried Chicken in the last.
Mm-hmm.
They have the 12 herbs and spices, and that's a trade secret.
Mm-hmm.
But let's say they came up with a way of making the chicken, like you were just saying. Well, you can maybe get a patent issued on the process of doing it. Let's say they used a material or some type of condiment that they made to enhance the flavor of the chicken. That would be a composition of matter. So they'd have a claim on that.
What about like jerk sauce or jerk seasoning?
Oh, you could get, depending on, you could get a patent on something like that. You're making it in its unique.
Mm-hmm.
It's never been done before. It's not anticipated. You still have the same bars that you have to pass.
Okay. So, what was the other example? You said you wanted to look at 3 particular issues or areas.
Okay, yeah. I wanted to show you a trademark where to do it on your own is really folly, and you might run into a lot of problems.
Mm.
So I was contacted by a potential client who wanted to sue somebody, and they want to sue them on a mark because they've been using this mark for their business, and they want to sue somebody for using their mark. But the problem is that mark really didn't belong to you. Somebody else had a mark. You were infringing their mark.
Okay.
To the average person, to the common person, they wouldn't know that they're infringing the mark because they don't have sufficient knowledge to understand what's going on in the mark. Now, here he started off where he wanted to sue somebody, but there's somebody, after he does this research, after his business has already been established and he's making money down the road, that he's found out that he's actually infringing somebody else's patent.
Okay.
Because that was what my assessment is.
Hmm.
So now, if that person sues you for using their mark, for taking away valuable income from them because you've been using their mark, for abusing the mark and using it incorrectly and all of these other damages, you now, instead of suing somebody, is being sued. So it can be funny how this thing works out.
Okay.
So that's one. What is the other one I was thinking about? I was thinking about a patent case where, it was the Kentucky Fried Chicken, I'm sorry.
Okay.
Where you could have multiple intellectual property rights. You could have a trademark right on the name KFC, You could have the right on the 12 herbs and spices, the methodology, and the composition of matter. So you can do it all in there. Plus, if there's a unique artwork involved, you may be able to get a copyright on the artwork.
Okay.
So you get in certain cases you may be able to get 3 different intellectual property rights.
Okay. I just wanted to ask you, Dr. Holness, your take on, let's say I hoping to have a festival of reggae music.
Okay.
Is there anything that I should be mindful of?
Okay.
I'm bringing a number of artists from across the Caribbean and Jamaica and Africa for this reggae festival. Is there something that I should be mindful of? Because music is, it's so very pervasive in our culture and our community, and it has such impactful value. So that is why I wanted to kind of speak to that.
Right. The question is, are you making the music?
No, I'm not making the music. But let's say I'm compiling the music. I'm taping it.
You have to have the right to do that.
Okay.
You can't. Depending on how they market, how they present the music,
Mm-hmm.
you might not have any right. You might not even be able to record it.
Okay. Even if I'm bringing the individual artists, I'm just talking having a reggae concert and bringing individual artists or a musical concert.
Well, you have no rights. The rights is with the creator.
Okay, the individual artists who are coming. Okay, so the investor then cannot record or shouldn't record and reproduce it.
Well, that's why these investors have spent so much money on attorneys.
Okay.
Because to be truthful, if you're in the music industry and you're going up against a producer, I suggest you have your attorney with you.
Okay.
Because you can give away the whole bathtub full of water and the baby.
Mm-hmm.
By signing something that you have just really pretty much signed your life away. If you're creating this music, the right to the music belongs to you. You have to be careful. That's another problem I should have spoken about is inventorship and authorship. If you have to find out who the author and who the inventor is, who the creator is, who does it belong to, really? That's always an upfront fight. That's from the beginning. That's what you need to know. Because as an author, as an inventor, as an owner, you have a certain right. You can, as an author or an inventor, you have a right to what you've invented or what you've created. And you alone are the one that can transfer it to other people.
Okay. So you would necessarily have to, like you say, register a trademark or some sort of.
Okay, as a patent attorney, if you came to me with a situation like that, I would register a trademark.
Mm-hmm.
Why not?
Mm-hmm.
It could grow, it could become recognizable, and you grow.
Okay.
So now we end up with a big yellow M.
Okay.
And if I show the big yellow M, that's a great function. He always has great functions. So you'd want to do trademark it if you can. You try to look for as many intellectual property rights that you can get. You go for it. Because that's only going to do what on the balance sheet to your assets. Increase it. And like you said, one other thing, I'm sorry to interrupt you. Like you said, that's money in the bank. You could take that down and actually tell the show, enhance your worthiness to the bank.
Right. I wanted to explore a little bit more, Professor Holness. You said something in the last segment which I found quite revealing. You said, are you recommending that as soon as you register business, that you should take out some sort of trademark or?
If you have a product, if you're selling a product, take out the trademark.
For example, what?
Let's say you have selling bags.
Handbags.
Yeah, and I'll show you how that works. That works. I showed you the McDonald's way it worked, but let's say I'm selling handbags,
Mhm.
and I have a regular handbag here, right? And I slap now it's a regular handbag I'm selling for $10. Now I slap a Gucci symbol on the bag. That's an entirely different bag,
Mhm.
even though it's made the same way. And anything. Just because I put that Gucci on there, I'm charging it $1,000 more. So it's always good to have your mark, build up your mark to that point. If you want to try to build it up to that point, so that when you put that mark on something, it enhances the value of the mark. It's like
Okay.
a golden touch.
So that is like branding then.
Yeah, exactly.
Okay, so can you expand on that a little bit more on branding and
Oh, okay. Branding is like that golden M we talked about. All you have to do is look at it and you automatically know. If we're talking about computers and I say Word, you know that is automatically. That's because Microsoft spent so much money on building it up. And if Microsoft take that to court, they're going to win because the court's going to say you put this much effort in it. This belongs to you. A half-eaten apple, slap it on the computer. Now imagine if I took some electronics from, let's say, Indonesia, China, for 50 cents, and I now bring in here a phone and I slap on an apple on it. That phone is increased in value exponentially. So that's because they built up that brand. The Apple brand was built up. The Gucci brand was built up. And so it would increase the value. So you want your brand. So it's good to start off with a brand. And every time you reach a milestone and you build on your brand, and the more popular it becomes, the more you increase your intangible assets.
okay. I had the experience of looking at a few videos produced in Nigeria, in Nollywood, and they're short videos, and the industry is quite a sizable industry. Some have put it at US $10 billion, some more. What would you say to people in small and emerging markets producing artistic stuff like that?
Okay.
I really wanted to speak to, emerging countries, emerging markets, and the implication of intellectual property and what they should be aware of and what they should be sensitized about.
What you should be aware of is it depends on the type of intellectual property. If you're dealing with trademark, don't tell anybody what your mark is until you have strong evidence of when you used it, because they can use your product against you, unless you have the evidence to support the fact that you've used it at a certain date.
Okay.
As far as music goes, I definitely look at copyright laws. Do not sign papers where you're giving away the rights to publish, your rights to do collections, to do compilation and things like that. So these are things you need to look at. Now, one of the things I would suggest is that they understand, or these people or countries understand what a trademark is and the importance of it, and other things. Because you may be able to get a trademark which will last for infinitum, as opposed to a patent. You may be able to get both, but a patent will only cover 20 years.
So why is a patent with limited lifetime? What's the thinking behind that?
Because the government, okay, that's a very good question, and that's a great question to ask. The government wants back, the patent is a contract. The government's giving you time to be the exclusive user, the exclusive owner of the product, of the patent. And for that, after it's done, you're giving them the patent to put into the public domain, and anybody could use it. So let's say you made a car and you're making billions of dollars with a car. Well, after 20 years, you now put the car into the public domain and somebody else can come along and start building cars and make money. So it's actually giving back its reciprocal. So that's what's,
Okay, and it provides competition. Does it?
well, the way how would you work a patent? You'd work a patent, you try to, once you get a patent on an invention, no one can use it, you're the exclusive owner. You would want to sell that patent, sell the invention on the patent or whatever it is for as much as you can. And as your time is going down, where you're now in 20 years, you sell as much as you can. As you're coming down, you're selling it less and less. So you hit rock bottom, which is marginal cost. So you'd still be dominating the field. One, you dominate the field with the patent, and then next you dominate the field because you're at marginal cost, and by that time you have the scale. You already have scale on your side. So this is thinking behind it.
Okay. So, Dr. Holness, a lot of people, especially with African ancestry and traditional ancestries, have brought with them, certain approaches to healing, skin products. How does that relate to intellectual property?
Yeah, those type of things would fall under patent law. Again, we're looking at novelty or anticipation. Has it ever been done before? The obviousness. I mean, you put oil and vinegar together. You have dressing. That's pretty obvious. You may say, yeah, you red vinegar, but what's the difference? It's vinegar. The next problem that you're going to face with something like that is the uphill battle of getting it past the FDA. You have to have proof that it doesn't harm anybody. You have to have proof that it does what it says it does. That also fell underneath the Drug Act of 1907, where people to stop snake oil salesmen from going around and selling stuff and saying stuff that's not true. So you have to have proof and you have to have ingredients. The combination of ingredients to form a composition of matter, then you be a composition of matter under patent law. The formulation, you depending on the novelty of it, should be able to get a patent on it. The value of the patent, I'm not quite sure.
Okay. Would you like to speak to any particular issue?
Right, I do. Firstly, should continue inventing, should always think of invention. Always. If we look around this room here.
When you say we should always think of invention, it's easier said than done. What do you mean concretely by that?
If you're a nurse working in a hospital,
mm-hmm.
and you've been doing a certain task, let's say you're making a bed.
Or a mechanic, for example, working on a car.
You're a mechanic, you're working on a car, and
Lots of mechanics around.
Oh, definitely, and I've filed patent applications for mechanics.
Here?
Yes.
In the Bronx? Wow.
In the Bronx. What happened was they took a tool and they modified the tool.
I've seen that before. Mm-hmm.
Patent.
Yes.
If it's never been done before, you get a patent on it.
Okay.
Wonderful thing to have a tool. You could make the tool or sell the tool to someone to do. So you always want to keep inventing. If you're in the field, think about how can I make something to invent? How can I invent something? One of the problems, the uphill problem, is that the people, they'll see a need, but they don't have the necessary knowledge and ability to.
What about resources?
What do you mean by that?
Resources, money. Is that generally, to your mind, a problem?
No, not in invention. In dealing with a prototype and things like that, there might be a problem with monies.
Mm-hmm.
But you don't need monies to invent something. You don't need a prototype. If you are a capable engineer, like you are, sir, and you have come up with an item or a method or an apparatus to solve a problem, you would have no problem in describing it to other mechanics. And if they can, by your description, go out there and make the product or make the apparatus, then you've passed muster of specific description.
You passed the smell test.
Yes, sir.
Okay. That's interesting. But you did mention a nurse too.
Yeah. A nurse. If a nurse look at the bed and how the bed, and maybe realize that you could actually make the bed to reach a certain position quicker if you did something else,
Right.
or if you added this,
Mhm.
that may be patentable. One of my favorite patents, there are two favorite patents I have, and I'm going to tell you. One of them is the straw. Someone was sitting there and came up with the straw. Means they were lying down on a chair on vacation, were kind of lazy, didn't want to put the glass in their mouth, and came with the straw. Patent. Now, the addition to that patent was a gentleman who saw his daughter. She was in about 1930, in the 1930s. She was at the fountain when she was trying to drink her milkshake, and she couldn't put the straw. The straw was too long, so he decided he was going to bend the straw, and he put a screw in there and wrapped up the straw, and it was able to bend it, and he received a patent.
On a straw.
On the bending, so the straw that bends,
Right.
you see bend,
That flexible bend in the straw.
came from him. He's the only one that had it. Now, another great invention is Post-its.
Mhm.
Post-its is wonderful.
Mhm.
So they came up with a glue that they realized that it didn't make it smudge, it didn't last for long. Well, what are we going to do with it?
Mhm.
Scientists went on with it and had to leave a message and put a Post-it, put a little glue on there and stuck it on the fridge.
Right.
And he had Post-it, $1 billion
Industry.
industry and invention.
Mhm.
So in most cases, you do need to know something about science and mechanics and mechanical engineering or electrical engineering and so on. But there are plenty of inventions out there where just good old
Simple common sense.
simple common sense, limited ingenuity, and you have a
Wonderful patent.
making billions of dollars.
Mm.
So, and by the way, that's one other thing. If you are going to go down the road of patent and intellectual property and then the trademarking, make sure that you believe that you're going to make some money, because this is about money. It's about commerce. Patents are about commerce. Trademarks about commerce. Trade secrets are about commerce. Copyright is in between. But copyright is more about art than commerce. So make sure that's one of the questions I always ask my clients. And I'm not trying to insult them. I'm just saying you're going to make a lot, because it might become expensive to go and get a patent or a trademark.
Okay. Professor Holness, you've shared with us quite a mouthful and shared with us very powerful information. You've opened our minds, you've stimulated our thoughts, you have opened us to new vistas, and I'm sure this is not the last time we'll be seeking you out and asking you to sit with us for a while. And I really want to extend my sincerest thanks to you for taking time out to share with us and our audience on reflections for a very, very deep and insightful program. Thank you so much for coming.
It's been a pleasure. Thank you for having me, sir.